In this video, we will discuss the difference between res judicata and estoppel, res judicata and withdrawal of suit, res judicata and stare decisis, res judicata and splitting of claims. Res judicata and estoppel. The doctrine of res judicata is often treated as a branch of the law of estoppel. Students, res judicata is really estoppel by verdict or estoppel by judgment. The rule of constructive res judicata is nothing else but a rule of estoppel. Even then, the doctrine of res judicata differs in essential particulars from the doctrine of estoppel, whereas res judicata results from the decision of the court. Res judicata results from the decision of the court. Estoppel flows from the act of the parties. Estoppel does not result from the decision of the court. Estoppel flows from the act of the parties. The rule of res judicata is based on public policy. There should be an end to litigation. Estoppel, on the other hand, proceeds upon the doctrine of equity. Res judicata and stare decisis. Res judicata means a thing adjudicated, a case already decided, or a matter settled by a decision or judgment. Stare decisis means to stand by decided cases. Stare decisis means to uphold precedents, to maintain former adjudications, not to disturb settled law. Those things which have seen, those things which have been so often adjudged ought to rest in peace. Res judicata and stare decisis are members of the same family, both related to adjudication of matters, both deal with final determination of contested questions and have the binding effect in future litigation. Both the doctrine are the result of the decisions of a competent court of law and based on public policy. There is, however, distinction between the two. Whereas res judicata is based upon conclusiveness of judgment and adjudication of prior findings. Stare decisis rest on legal principles. Students, res judicata bind parties and previous, whereas stare decisis operates between strangers also and binds court from taking a contrary view on point of law already decided. Res judicata relates to a specific controversy. Stare decisis touches legal principles. Res judicata presupposes judicial finding upon the same facts as involved in subsequent litigation between the same parties. Stare decisis apply to same principle of law to all times. Res judicata and withdrawal of suit. Order 23 Rule 1 deals with withdrawal of suits. It enacts that where the plaintiff withdraws the suit or abandons his claim without the leave of the court, he will be precluded from instituting a fresh suit in respect of the same cause of action. The distinction between res judicata and withdrawal of suit lies in the fact that while in res judicata the matter is heard and finally decided between both the parties. In withdrawal of suit, plaintiff himself withdraws or abandons his claim before it adjudicated on matters. In res judicata, former suit is decided, but in withdrawal of suit, plaintiff withdraws his claim. Suit is not decided in withdrawal of suit. Res judicata and splitting of claims. The doctrine of res judicata also differs from Order 2, Rule 2 of the Code of Civil Procedure. The res judicata refers to a plaintiff's duty to bring forward all the grounds of attack in support of his claim, while splitting of claims only requires a plaintiff to claim all reliefs flowing from the same cause of action. While the res judicata rule refers to both the parties, plaintiff as well as defendant, and precludes a suit as well as defense. Splitting of claims refers only to plaintiff and bars a suit, We can say that res judicata rules refers to both the parties, plaintiff and defendant. But splitting of claim refers only to a plaintiff and bars a suit. Students, please like the video, share the video and subscribe the YouTube channel. Please feel free to contact us for any help in preparation of judicial services examination. We will be very happy to help you. Thank you.